Workplace complaints like bullying and harassment are increasingly difficult issues for businesses in particular, but many are grappling with just what to do when complaints are made anonymously or when someone wants their anonymity to be preserved. A recent decision of the Supreme Court of Western Australia has confirmed exactly what the scope of an employer's responsibility is in these situations. And here to discuss a recent case with us then is our workplace law commentator, Joydeep Hor, Managing Principal of specialist employment law firm People and Culture Strategies, kindly joins us on these issues often. Thank you very much, Joydeep. Yeah, it's a really interesting one and it kind of goes to the question of how far confidentiality extends when you have some of these claims made. Just walk us through this case.
Yeah, so it is a very common issue. As you said, bullying and harassment complaints in particular are very much dominating the landscape of employee grievances. And what we see happen a lot is that someone will bring an issue to the attention of their employer, to their manager, and they'll say, look, I'm making a complaint about this. I didn't like something that's happened, but I don't want it to be known that I have made a complaint. Yep. And this is exactly what happened in this particular case, where it was a mine site. An employee complained against a female co-worker that the way in which the female co-worker had been dressing was a little bit provocative and suggestive, etc. But they didn't want their name to be attached to the complaint. Now, it gets escalated to management, and then they treat it as a safety issue because their concern was, well, if that is the case, in a male-dominated work environment, we've got safety obligations to her and it could all end badly. So they conduct an investigation. They find that there's no wrongdoing on her part. Unsurprisingly, she forms a view about the conduct of the person who's made the complaint and takes issue with it, contemplates, we can only imagine...
Because she denies the allegations. She said, well, hang on, that didn't happen. I want to know who's made that complaint about me.
That's right, with a view to perhaps commencing defamation proceedings. And so the employer resisted providing the name of the person to her, saying, well, no, it was made confidentially. We will protect the anonymity of the individual. So she made an application to the Supreme Court of Western Australia asking for an order that the court compel the employer to disclose the identity of the person who had made that complaint. Now, it's such a common issue.
She's terminated for separate reasons.
Correct.
Right, so that's kind
separate
of...
reasons altogether,
but she's still very upset about it, obviously.
Absolutely, and an important context, I guess, in terms of the headspace that employer would no doubt have been in. But what was really interesting was this is the first time, at least as far as I'm aware, where this issue has actually been tested in an external court environment. But it's an issue that employees who have complaints made against them and who don't have the identity of the person making the complaint disclosed to them feel very strongly about, and they do want to take defamation proceedings or at least understand their rights. And the court said in this particular case that, look, yes, on its merits, you are satisfying all of the criteria to have me make the order, but I won't make the order because in this particular context, the employer, the company, had policies that were very clear that committed to maintaining the confidentiality if someone made a complaint confidentially. If the organisation in that case didn't have those kinds of policies, I think the outcome would have been quite different. And so what is very important, recognising how common this issue is that if employers are going to take a strict view about confidentiality and not disclose the name of a person making a complaint in circumstances such as this, they just need to be careful that they've actually got the backing of an infrastructure within their organisations, like policies, like procedures, that say, you know what, we will keep it confidential. Because the judge in this case said, look, it makes a mockery of those policies if all the person has to do is make an application to the court and then I just unwind everything that's said in those policies and say, well, no, it doesn't matter what's in those policies. I'm ordering you to disclose the name of the person.
I'm just thinking that from the employee's perspective, the one whose the allegations are made against, it doesn't seem very fair that just because a company's written a one line somewhere in a policy and they've ticked that box, that then their kind of name can be dragged through the mud.
Exactly,
that confidentiality of the accuser is kind of maintained.
Well, the competing interests in all of these matters has for a long time been a tension for employers. You've got obligations to the person making the complaint, you've got obligations to the person against whom the complaint is made. But one of the real challenges for employers is that and the reason why they do have those kinds of clauses in there is because the employer will say, look, if we can't give assurances as to confidentiality, people will not report these matters to us. And we've got health and safety obligations. We're ultimately trying to ensure a better workplace, a better culture, make sure we can...
How do you stop people just taking advantage, saying, well, I know that they're not going to say my name, so I'm just going to put people can just put forward accusations willy-nilly, can't they?
Sure, they can. A lot of employers will deal with that by saying if it is found upon investigation that you have made a complaint on a vexatious basis or frivolous basis, we might actually take disciplinary action against you for doing that. So that's the protection, that's the safeguard. And in fact, that was an issue that was addressed in this particular case by the judge, where the judge said, look, if this was a comment that had been made about the female employee, and he says in the mess area, so a generalised remark made in front of a lot of people, that's a very different story. However, when a person invokes the protection of a policy, it's not gossip and innuendo, they're raising it with a manager, they should be entitled to the protections of that policy where the policy is clear that those protections will be given.
Brilliant. It's a fascinating case. Thank you very much. And as you said, one that is coming up more and more often, I suppose. So thanks very much, Joydeep.
Thanks, Brooke.
That's Joydeep Hor on workplace complaints and, how far confidentiality extends in those situations.